To order. Will the clerk please take roll call attendance?
Madam Chair.
Here.
Senator Archambault. Senator Raptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer. Senator Lombardi.
Here.
Senator Casada.
Here.
Senator Rogers.
I'm here.
There are 6 members present. You have a quorum.
Thank you, Mr. Clerk. We have 5 bills on the agenda for consideration this evening. I would like to address those bills now. First is Senate Bill 55 by President Ruggiero. We have a sub-A on this bill. May I have a motion to indefinitely postpone Senate Bill 55 and bring forward to the committee Senate Bill 55 sub-A?
So moved.
Thank you. So moved by
Second.
Senator Lombardi, seconded by Senator Raptakis. Mr. Clerk, will you please take a roll call vote?
Madam Chair.
Yes.
Senator Raptakis.
Yes.
Senator Burke.
Yes.
Senator Lombardi.
Yes.
Senator Casada.
Yes.
And Senator Rogers.
Yes.
There are 6 in the affirmative and none in the negative.
Thank you, and the bill is properly before this committee. The sub-A, to remind the committee, this act would establish procedures for employees to file complaints with a hospital or the Director of Department of Health for any assaultive behavior or other violation of law occurring on hospital grounds, and require hospitals to institute safety training for employees. A few of the changes that the sub-A makes: cleans up definition of workplace violence to remove a reference that was not appropriate. Number 2, revise the notification section to allow an employee to notify his or her employer or Rhode Island Department of Health, but does not need to notify both. It revises to require Rhode Island Department of Health to notify the hospital after receiving an employee complaint, so long as abiding by confidentiality requirements. Number 3, it revises retention of records section to do the following. Only an employee directly involved in an incident can be given access to records. It allows an employee representative or workplace safety committee to have access to an incident report, so long as the reporting employee name is excluded. And it revised the effective date to be January 15, 2022, in order to allow time for this implementation. Do any committee members have any questions on this? Thank you. Seeing none at this time, may I have a motion to pass Senate Bill 55 sub-A?
So moved.
Thank you. Senator Lombardi made that motion, seconded by Senator Rogers. Mr. Clerk, will you please take a roll call vote?
Madam Chair.
Yes.
Senator Raptakis.
Yes.
Senator Burke.
Yes.
Senator Lombardi.
Yes.
Senator Casada.
Yes.
And Senator Rogers.
Yes.
There are 6 in the affirmative and none in the negative.
The vote is 6-0, and Senate Bill 55 sub-A passes to the floor. I would like the clerk to record that Senator Archambault is present. And Senator Archambault, would you like to be recorded in the affirmative on Senate Bill 55 sub-A, which we just passed to the floor?
Yes, please. Thank you.
Thank you, Senator Archambault. Next bill up on the agenda for consideration is Senate Bill 609 by Senator Paolino. This allows jurors to donate their juror fees to the state. Any such donation would be deposited into the general fund. Do any committee members have any questions on this bill? And I see Senator Oyer is present. Also, Senator Oyer, would you like to be recorded in the affirmative on Senate Bill 55 sub-A, which we just passed to the floor?
Yes, please. Thank you, Madam Chair.
Thank you. All right, back to Senate Bill 609 by Senator Paolino. If none of the committee members have any questions, may I have a motion to pass Senate Bill 609? So
Motion
moved
to
by
pass the floor.
Senator Rogers, seconded?
Yep.
By Senator Burke. May I have a roll call vote, please, Mr. Clerk?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Raptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Casada.
Yes.
And Senator Rogers.
Yes.
Yes.
There are 8 in the affirmative and none in the negative.
The vote is 8-0. Senate Bill 609 passes to the floor. Next is my bill, Senate Bill 675. And this act would provide that financial security is required for any motor vehicle registered or required to be registered in the state of Rhode Island. And this bill was introduced at the request of the courts on behalf of the Traffic Tribunal. Do any committee members have any questions on this? Seeing none, may I have a motion to pass this bill to the floor? That's Senate Bill 675. Motion made by Senator Archambault, seconded by Senator Raptakis. Mr. Clerk, can I have a roll call vote, please?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Reptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Casada.
Yes.
And Senator Rogers.
Yes.
There are 8 in the affirmative and none in the negative.
The vote is 8-0. Senate Bill 675 passes to the floor. Next on the agenda is Senate Bill 677 by Senator Reptakis, an act relating to courts and civil procedure, traffic tribunal. It vests the traffic tribunal with jurisdiction over the adjudication of alleged violations of the harassment of hunters, trappers, and fishers law. And the bill was introduced at the request of the courts for the second time on behalf of Traffic Tribunal. Do any committee members have any questions? Seeing none at this time, Senator Reptakis moves passage. Seconded by Senator Lombardi. Mr. Clerk, may I please have a roll call vote?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Reptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Casada.
Yes.
And Senator Rogers.
Yes.
There are 8 in the affirmative and none in the negative.
The vote is 8-0. Senate Bill 677 passes to the floor. Finally, we have Senate Bill 734 by Senator DeMario, an act relating to human services, abused and neglected children. And this act would establish a military family advocacy program to address child abuse and neglect in military families. The bill was introduced at the request of the Department of Defense and the Navy Station, Newport. Any committee members have any questions? Seeing none at this time, may I have a motion for passage? So moved by Senator Archambault, seconded by Senator Reptakis. Thank you. May I have a roll call vote on that, Mr. Clerk?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Reptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Casada.
Yes.
Senator Rogers.
Yes.
There are 8 in the affirmative and none in the negative.
The vote is 8-0, and Senate Bill 734 passes to the floor.
Madam Chair,
yes.
I'm sorry to interrupt. Before we get on, is 259, I think that's scheduled for consideration. I don't know that we took that unless I have an older version of the agenda.
Yes, the agenda has been updated, and that's been taken off the agenda at this time.
Thank you.
Thank you for bringing that to my attention. That will not be heard today or considered. Next, what I'd like to do, we do have a long agenda, but I'd like to take out of order the 4 solemnization of marriage bills at the end of our agenda and bring them forward for hearing or consideration. I'd actually like to bundle these bills for consideration, and they are Senate Bill 885 by Chair Felag, House Bill number 622 by Rep. Quattrochi, House Bill 6221 by Rep. Quattrochi, and then House Bill 6242 by Whip Kazarian. If there are no questions by committee members, do I hear a motion to pass all 4 of these bills? By the motion made by Senator Archambault, seconded by Senator Oyer.
Second.
Mr. Clerk, may I please have a roll call vote?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Reptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Casada.
Yes.
And Senator Rogers.
Yes.
There are 8 in the affirmative and none in the negative.
The vote's unanimous, and all 4 bills have passed to the floor. Again, our committee has another full agenda. Today, we'll be hearing 15 bills. In keeping with existing virtual protocol for this committee, I would ask for a motion to hold all 15 of these bills before us for further study.
Motion to hold.
Thank you, Senator
Second.
Rogers. Thank you, Senator Casada. Second that. Mr. Clerk, will you take a roll call vote, please?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Reptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi,
Yes.
Senator Casada,
Yes.
and Senator Rogers.
Yes.
There are 8 in the affirmative and none in the negative.
Thank you. It's unanimous, and all 15 bills will be held for further study. As I normally say, in an effort to utilize both the sponsors and the public's time more efficiently while conducting these hearings virtually, I will ask each of the sponsors, if they're present, to introduce and explain their bills. Upon conclusion of the sponsor's introduction and explanation, we'll then take public testimony. So we'll go, let's see, the first bill up we have is Senate Bill 665. Okay, I see Senator Mack on. This bill is an act relating to criminal offenses, disorderly conduct. It amends the penalty provisions for disorderly conduct, willful trespass, and shoplifting. Welcome to the committee, Senator Mack. Would you like to introduce this bill and explain it?
Yes, thank you, Madam Chair. This bill is an attempt to re-understand the ways in which we criminalize people in our communities who are oftentimes victims of a system that does not allow them to have the resources that they need in order to survive. Oftentimes, folks who are charged with disorderly conduct, with the changes that I have to this bill, are charged up to $1,000. This moves that penalty down to $500, which is a little bit more manageable, especially for people who are lower income. $500 might as well be $1 million for many people who work paycheck to paycheck and make less than $15 an hour. And then for the offense of non-willful trespassing, it changes this from a misdemeanor to a violation, also keeping that penalty between $500 and $1,000, because again, folks who are low income, $500 again might as well be $1 million for them. And I think that's more than enough punishment for someone for a violation offense. And then for shoplifting, as we begin to understand our communities and people who commit these crimes of survival, especially when you have mothers shoplifting for baby formula because they cannot stretch their EBT with benefits, or don't have the means necessary to provide for their family, which are really heartbreaking cases. As we begin to stop criminalizing people for the systems in which they live in, and understanding where they're coming from, and that they're often committing these crimes for survival and not for malicious intent. Moving those fines down to civil violations, preventing incarceration, especially for young families and family members, and moving those violations between $100 and $1,000 to exceed no more than double the amount of property that was stolen. And with that, I have questions from this committee.
Thank you, Senator Mack. Yes, Senator Rogers has a question.
Thank you, Chair. Just a quick one, Senator Mack. This, there is nothing dictating that a judge can charge $100. This is simply not to exceed. So even if it was at $2,000, the judge doesn't have to charge that. He has a ceiling of that. So I think, you know, I don't know why we're trying to bring the ceiling down. I think it should be left by the judgment, and those things may be taken into consideration. But if you have repeat offenders, you know, maybe they'll start going up a little bit to the max. I think by lowering the max down, there's nothing stopping a judge from giving a $50 fine if the maximum's up to $500. Am I correct?
Senator Mack?
Well, in legislation, no, but in practice, there is inherent biases that many people have, and it is a well-documented fact that many folks, especially people of color and lower income people, are often charged that maximum, whether or not they're repeat offenders or first-time offenders. This would just lower that threshold to $500 for first and second-time offenders, and up to $1,000 for third-time offenders in the case of a trespass.
Senator Archambault has a question. Senator Archambault has a question.
Yeah, I just have to respond to that, Senator Mack, respectfully. This is an area where I just can't sit quiet. I've been prosecuting for decades here, 4 towns. I'm in court every week. Wednesday I had probably 70 cases from 3 different towns. I can't tell you how many shoplifting cases were in there. The question of whether it's a person of color never enters the equation. Not even looked at. Not even a relevant factor. What's looked at is 3 things: the criminal record or lack thereof in one hand, the charges in the other hand, and then the facts. A prosecutor will argue aggravating facts. Look, they went in, they're first offender, but they shoplifted shrimp, and they shoplifted, some items that aren't survival things in there. And I'm playing the devil's advocate because there's another side to your argument. And those items and the intent to take those items clearly didn't have to do with survival. And then the defense attorney will come in and they'll argue mitigating factors. They'll say, well, look, they don't have any prior criminal record. It is their first offense, shoplifting. So then what do I do as a prosecutor? I say, well, all right, maybe a letter of apology, some community service, a small monetary contribution. I'll work with them because, as Senator Rogers was onto, there's discretion already built into the system, and that discretion is a range that can be used within the system. I think the spirit of what you're trying to do in terms of the shoplifting provision is sound in the sense that you want there to be more leniency for the first offense so that somebody will be able to get on the right track. Where I think you have to be careful, though, is in painting with a broad brush here and saying that everybody who shoplifts is typically somebody from a really hard economic background and they're doing it only for survival. If that is the case, I pick up on it, the defense attorney picks up on it, the judge picks up on it. There tends to be great sympathy, and we open the doors to a path that's going to lead the person on, hopefully, some rehabilitation and never to do it again. Conversely, if there's somebody who has a history, when I look at those three things and I see that they've shoplifted, 20 times, and they've avoided being convicted of felonies because of the dollar value, so they're not charged with a felony, but they've got, I had someone last week, I think they had 11 shopliftings on their record, and they hadn't been convicted yet, so they didn't rise to the level of felony, astoundingly. Is that a person that I should treat in the same measure that you advocated for with your, argument that the people are downtrodden? No, that's a rhetorical question. No, absolutely not. That person should get another pound of flesh taken out of them because they're not doing it purely to survive. They're either doing it to feed a drug addiction, and if that's the case, we try to get them into pretrial services or get them on a path where they can get the help they need. And there isn't this mindset in the court to hurt people. It's a mindset of just desserts, trying to be equitable. And so, again, I think that already inherently exists. One more point: disorderly conduct. Disorderly conduct, in my eyes, is never a civil violation. What disorderly conduct very often is a physical assault where the person doesn't want to go forward in the case with the simple assault, but it's maybe witnessed in front of a police officer or several witnesses. It tends to be a lesser included offense. And then typically when you're trying to work out a disposition, you can either dismiss that charge or give them some community service or set them on a different path. But disorderly conduct, I don't think in any way, shape, or form should be a civil violation. I just want to point out, several years ago, we had a study done, a justice study done, and justice reform. And I forget the exact name for it. Remember? Reinvestment program. Thank you, Chair. And Judge Savage led that program. And Senator McCaffrey has bills in that are designed to reflect the updates in that with petty misdemeanors and all. Disorderly conduct was intentionally not put in as a violation in that study, and I think for good reason. Anyways, I've said enough. Thank you.
Thank you very much. If there are no other questions, Senator Reptakis.
Real quickly to Senator Mack, do you have any data that you can share with the committee, regardless where the target of this bill is for minority individuals? Because we like to see the data, because I think Senator Archibald did bring up a good point. We're just going to be very careful where we proceed on tinkering with especially the jurisdiction of the judge and allowing the judge to make that decision. I don't want to go repeat what Senator Archibald had said earlier, but I think we're just going to be very cautious how we proceed on this legislation. If you do have that information for us, something that maybe is recorded in the court system as far as those that are being charged or arrested, if you can share that information with the...
I'd be more than happy to, Senator Reptakis, to share those numbers. And just some brief numbers: 1 in 3 Black Americans are likely to be arrested over their counterparts, and Latino males are 3.1% more likely to be arrested. I can find the specific numbers that include Black and brown individuals being more likely to receive lengthier sentences and higher fines for the crimes they commit. And I think that is, and while I do appreciate the expertise and lived experience that Senator Archambault has, I think that is also a very specific instance of working in very specific court environments. And I think the larger problem is endemic to the system itself. Inherent biases are going to be within our communities, but I'm more than happy to share that data with this with this committee so that you can see the backed numbers and research that has gone into years and years of understanding sentencing and fines that are applied to often Black, brown, and low-income people, which are disproportionately higher than the population.
Yeah, we want to make sure those figures are from within Rhode Island only, because we've done a lot of work. This committee's done a lot of work. A lot of those individuals that served on the Justice Reform Commission did a lot of work. So we want to show that the work that we've done has reflected and helped those members of the community. So I want to be specific and get those numbers from within Rhode Island only, because Rhode Island has been a leader as far as judicial reform. I don't care what anybody else does in New York or Pennsylvania. They have problems, but it's what we do in our home state. Thank you very much.
Thank you, Senator Reptakis. And Senator Mack, I believe you have another bill on for today. It's 771. While we have you with us, if you want to introduce that bill and explain it, it's an act relating to criminal offenses, commercial sexual activity.
Yes, just 1 second. Let me grab my notes. So this next bill would decriminalize commercial sex work in Rhode Island, changing it from a misdemeanor to a civil violation, and changing the fines from up to $500 to up to $250. Again, these are often folks who are using commercial sex work and sex work as a means for survival. It is oftentimes a victimless crime, though there are many people who are trafficked and are subjected to commercial sex work. I believe as we come to understand communities better and folks who are engaging in this type of economy and really respecting all folks' access to commerce, we can start not only decarcerating people, but also preventing people from entering into the criminal and legal system in the form of creating fines and more supports for people. Because oftentimes, especially when folks are using sex work as a tool for survival, they're in need of more resources in their communities, in their lives, and less jail time, which often doesn't solve the problems which are endemic to the situations that led them to commercial sex work in their lives. So this would change it again from a civil penalty to a civil penalty, and change the fines from up to $1,000 to up to $250. Again, these are folks who $250 might as well be $1 million for people who are working paycheck to paycheck, especially for street-based sex workers who are often facing some really hard circumstances, including opioid drug abuse and other problems that are endemic of a failing system that has not yet provided our communities with a reliable paycheck, mental health services, and robust triaging program for folks that have mental or behavioral health problems. And I'd be happy to answer any questions about this piece of legislation.
Senator Archambault, I believe,
Yeah,
has a
thank
question.
you. Well, Senator Mack, I'm going to flip my hat here a second where I kind of open up on you on the other bill about my concerns about it. Here, I think you're on the right track. I think this bill is probably overdue. I think the civil violations are sound, the first 1 and 2. The only thing I'd ask you to look at here is, I don't have a crystal ball, but there's a piece of legislation in to create a mental health court. I hope that passes this session. I co-signed it. It's Senator McCaffrey's bill. It's long overdue. Very often I'm in court with somebody who has mental health issues. I mean, I'm a lawyer, and I could be doing it for a long time. I'm not qualified. I try my best, but I'm really looking forward to having a whole separate court with clinicians that can help the person, get them on the right path. Ultimately, we dismiss it, right? Just like we would drug court. And these kind of cases could dovetail perhaps into that court, get somebody the help they need if there's a drug issue or whatever the reason is, help them, right? But I think you should keep maybe your mind open a little bit to the possibility of a third section, a subsection that says, look, and I don't know which offense to pick, but at some point, if somebody's got 5, 6, 7, 8 of these offenses, they can't keep being civil violations. It's kind of what happened when I had the bill that decriminalized suspended licenses. That was one of my goals when I got here. I thought it was terrible that we had criminal offenses for suspended licenses. So we had the first two be civil. I thought those fines should be even lower. I didn't think they should be $250 and $350. I want them to be $100, $200. I didn't want you to have to pay court costs, right? And it didn't work out that way, but at least we kept the first two as civil, right? But at a certain point, the third one becomes criminal. Sometimes I get people in front of me who have 15 suspended licenses in a short period of time. That person's not going to learn their lesson from monetary fines. Sometimes the only way they can learn their lesson is with some criminal penalty. I'm not saying incarceration, but maybe some other criminal sentence, a filing, probation. So, it's your bill, just a suggestion. You may want to think about what level would it hit the point where it should become a criminal charge. And that doesn't negate the fact that it ultimately still could go into a mental health court. They do the right thing, even if they had 8 of them, 10 of them, and still get it dismissed. You follow me?
Yeah, no, that's a really good point, and I look forward to incorporating that into this piece of legislation.
Thank you, Senator Mack. Any other questions of committee members? Okay, thank you for joining us this evening, Senator Mack. We appreciate it.
Thanks, Madam Chair.
We have 2 other senators who are not on Judiciary Committee that I would like to take, so they could move along to other committees. I believe we have Chair Cano on the line or on WebEx. Chair Cano, can you hear me? How about Senator Paolino?
I am here, Chairwoman.
Okay, very good. Senator Paolino, Senate Bill number 598, an act relating to health and safety vital records. Would you like to introduce that and explain it, please?
Absolutely.
Thank you.
Thank you, Chairwoman and members of the committee. This act would require the Division of Vital Records, upon the filing of a death certificate, to file a written or electronic notification of the name and address of the deceased with the Office of the Secretary of State and the chairperson of the Board of Canvassers of the city or town listed on the death certificate for the purpose of removal from the rolls of registered voters. The 2 most common ways that people are found on the voter rolls who should not be there is when the officials don't know that they've moved or if they've died. In October 2016, we learned that Rhode Island had over 700,000 people listed as eligible to vote, with 592,672 registered voters, in excess of over 189,000 voters, people. I am not sure we are doing much better 4.5 years later. We still need to have a mechanism to remove the deceased from Rhode Island from the voter rolls. We need to clean up that list for the integrity of our election systems. This is a huge way to help that happen, and I welcome any questions.
Thank you, Senator Paolino. Any questions for the senator from committee members? Okay, I don't see any at this time. Thank you for joining the Judiciary Committee this evening.
Thank you very much, Chairwoman. Do I have anything else here tonight?
Let me do a double check. I don't see any.
Thank you very much.
You're welcome. Okay, next, Chair Cano, you have bill number 799, an act relating to elections, registration of voters. Would you like to introduce and explain that?
Thank you so much, Chair, members of the committee. I'm really happy to be in front of you. So this act would increase the role of the Division of Motor Vehicles in the voter registration and address verification process by establishing a very specific obligations. It would also protect from disclosures to the federal government any documents produced pursuant to these new voter registration procedures. So since the passage in 2017, automatic voter registration has made Rhode Island's voter system more secure, accurate, and efficient. Now the Ocean State has the opportunity to expand upon those improvements with the back-end automatic voter registration. The back-end automatic voter registration is proven to be the most effective policy for adding eligible voters to the rolls and securely updating voter lists with accurate address information, all while ensuring that people who are not eligible are protected from inadvertently registration within the system. Because eligibility voters are met with unexpected, potentially confusing prompts while completing a transaction at the DMV, more eligible Rhode Islands can be automatically added to the voter rolls, and our state electorate can be more accurately reflect of its populations. This means when eligible voters show up to the polls on election days, there is no doubt that that information is accurate and up to date on the voter rolls. Backend ABR also helps guard against human error and clerical mistakes, all by eliminating the possibility of erroneous data entry, and it saves money. I want to make sure that I let the committee members know that it also which is very important. If a person is ineligible to vote because of their age or immigration status, they are automatically excluded for any voter registration process. In this way, backend automatic voter registration protects people who are ineligible while ensure our rolls only include eligible voters. I want to make sure that you all know that these type of process have already been passed in different states, including our neighbor in Massachusetts and other states around the country. So pro-voter activists and organizations in Rhode Island believe we should bring back in automatic voter registration to our state, and the reason why is because it has been a proven track record across the country, like I mentioned, for securing the voter data, improving out-of-date registration systems, and increasing overall eligibility voter registration. We must continue to work with the legislation and the Secretary of State Gorbea to make sure back-end automatic voter registration is successfully adopted, hopefully in 2021. And I'd like to also mention to members of the committee that there is some technicalities that needs to be changed in the bill based by a conversation that we did have with the Secretary of State's office. So we're waiting on those technical changes, but I hope that after that come in, you truly consider this legislation that is so important for Rhode Islanders, and it will maintain broader access to voter registration. Like I said, it had already passed in Massachusetts and in other states. So this is a cutting-edge voter registration technology, and it will ensure that voters across the ocean states have a chance to make their voices heard and uphold a truly representative democracy in our state. And with that, I will take any questions.
Thank you, Chair Cano. Any questions of committee members? Okay. Seeing none at this time, thank you for joining our committee this evening. Okay, I think we'll revert back to the beginning of the agenda, and we'll revert back to Senate Bill number 667 by Senator De La Cruz, an act relating to criminal offenses, sexual assaults. I'll introduce that. I don't see around, but if any of our other senators join us, I'll be happy to entertain their description of the bills. This defines an act of sexual penetration or contact perpetrated by an individual with a position of authority upon a person over the age of 14 and under the age of 18 as third-degree sexual assault. Any questions? Okay, moving on. Senate Bill number 740 by Senator Lombardi. Senator Lombardi, would you like to explain your bill?
Thank you, Madam Chair, ladies and gentlemen of the committee. This is very straightforward. This is making amendments to the Healthcare Facilities Abuse Statute by eliminating the intentional requirement as provided under the definitions and other sections regarding neglect. So now the offense can be merely engaging in a pattern of harassing conduct rather than intentionally engaging, and eliminating from the word neglect the intentional requirement, which is kind of an oxymoron in the first place, to have intentional with neglect in any event. I think it's a good bill, and I'll entertain any questions that you may have.
Thank you, Senator. Any questions of committee members? Okay, very good. No questions at this time. Thank you, Senator. Our next bill is Senate Bill 796 by Senator Gallo. It is an act relating to education, health, and safety of pupils. It amends the definition of dating violence to include abusive, coercive behaviors used to exert control and power provides that abuse may be physical, verbal, emotional, sexual, financial, or psychological, and includes threats, isolation, and intimidation. Any questions? Okay, moving on. Next is by Chair Oyer, Senate Bill number 797. Would you like to introduce and explain your bill, Senator Oyer?
Thank you, Madam Chair. Yes, this bill is making updates to the Good Samaritans Act to basically include language that would allow the protections under that act to apply if an individual was exhibiting medical emergency that was unrelated to a drug incident. So as we know, the Good Samaritan Act, we passed that, or this legislature passed that bill in an effort to try to save lives, because what ends up happening is that in drug-related situations, when someone exhibits a medical emergency, oftentimes people will be afraid to call for help because they are afraid that they will be prosecuted. So the Good Samaritan Act is really intended to try to save lives and encourage folks to call for help. What happens though is that, if there is a medical emergency, the person that is with them may not, if they're not a medical expert, aren't going to know whether or not it's related to the drugs or not. And so this is really trying to expand the definition to provide additional protections and encourage folks to call for help. One thing I wanted to point out in some written testimony that we got from the Department of Health is that drug overdose is the leading cause of accidental death in the United States, and the most common drugs associated with these deaths are opioids. Rhode Island saw a decrease of 8.3% from 2016 to 2019. However, accidental drug overdose deaths in Rhode Island increased by 25% from 25% of 308 individuals in 2019 to 384 individuals in 2020. So I think this is a really important adjustment to the law, and I would be happy to answer any questions.
Thank you, Senator Oyer. Any questions? Seeing none at this time, I believe you have the next bill, which is Senate Bill 834. Would you like to introduce that, please?
I would. Thank you so much. This law this legislation is pretty simple in that it removes the specification of not being the spouse from the first-degree sexual assault statute. I want to thank Leader McCaffrey has been working on this issue for a while, and he and I have been working on it together for the past couple years, and COVID hung us up last year. So really, this is another very simple bill. I think it takes out a very antiquated loophole that right now, if someone were to sexually assault their spouse, they would not be able to be charged with first-degree rape under Rhode Island law. I think that is a travesty, and that needs to be corrected. So that's why I put this legislation in, and I would be happy to answer any questions.
Thank you, Senator Oyer. Any questions of committee members? Seeing none at this time, we'll move to the next couple of bills are from Senator Morgan, and I don't see her online, so I will just read them into the record to introduce them. Senate Bill 662 by Senator Morgan, which is an act relating to elections mail ballot. It requires that only the mail ballot voter, their spouse, court-appointed guardian, cohabitant, or any adult person related to the voter by blood or marriage be allowed to physically mail the voted mail ballot. Her next bill is a Senate Resolution number 663, entitled Resolution to Approve and Publish and Submit to the Electors a Proposition of Amendment to the Constitution, General Assembly to review the regulations. And finally, Senate Bill 666, also by Senator Morgan, an act relating to elections, mail ballots, conduct of election and voting equipment and supplies. It requires any person voting by mail ballot or emergency mail ballot to provide proof of identity, exempting those who are hospitalized or residents in a hospice or skilled nursing facility. which now brings us to Senate Bill 738 by Senator Archambault. Senator Archambault, would you like to introduce your bill?
Yes, thank you, Madam Chair. Let me just pull this up. So this act, in a nutshell, it's designed to enable disabled and military voters to use the electronically transmitted ballot system. Currently, the only system we can use in Rhode Island for such individuals is the fax machine. And I submit to you that the fax goes by the way of the dinosaur. People will say to me, "You still use fax?" And it makes me seem like I'm, 100 years old. Essentially, it's going to allow the Secretary of State to electronically transmit ballots to and from eligible voters only through a service or solution that meets the following requirements. The system has to have one or more independent security reviews. It has to demonstrate that the system meets the National Institute of Standards and Technology, the NIST, Cybersecurity Framework Guidelines. That's the big fish that monitors this stuff nationally. And it has to be approved by the Secretary of State, and that language is in the bill. It basically tightens up the security of a system that's already in place in the state and will help thousands of Rhode Islanders vote privately and independently. And I want to note here that the FBI, the Department of Homeland Security, and all other federal agencies do not transmit their sensitive or classified information by fax machine, for the reasons I just said. They're with it, not in the dinosaur age. They are required to transmit their email over secured portals. There are other comments I have on here about the benefits of it, but particularly when it gets into people with disabilities. And we have such a significant portion of our state who are disabled. Put aside for a second the super noble sacrifice of those who are in the service of our country overseas and can't cast their vote. We certainly don't want them to be disenfranchised, but let's focus on the disabled for a minute. People that are disabled, there's a report that gets at it's called Projecting the Number of Eligible Voters with Disabilities. And it was November 2020 election study, and it was issued around that time by Rutgers University, and that's the leading university for the study of disabilities. And the report noted that there are projected 38.3 million people with disabilities eligible to vote in the November 2020 elections, representing close to 1/6 of the electorate. Think about that for a second. 1/6 are disabled. The report also broke the number down by state. Rhode Island had 135,000 voters with disabilities, or 17% of the state's electorate. We all know how hard it is to get people to turn out for elections to begin with. And then you have all these people who are disabled, probably in everybody's family there's somebody who's been touched by a disability or has some disability, and they can't get out to vote. I'll leave it with this, and I'll take questions when it's my turn, Madam Chair. But the AARP, United Cerebral Palsy, National Multiple Sclerosis Society, Rhode Island Governor's Commission on Disability, National Council of the Blind, and the National Federation of the Blind, and a host of other advocates have all written letters on support of this bill. And when my time comes, I'll certainly take questions. Thank you.
Thank you, Senator Archambault. Any questions of committee members? Okay, we don't have any at this time. Thank you. The next bill is my bill, Senate Bill 835, introduced on behalf of the Secretary of State. This act would authorize the Secretary of State and Board of Elections to conduct an extensive cybersecurity assessment of our election systems and facilities, and to establish a cybersecurity review board to review and assess our election system. It also creates a cybersecurity incident response group to adopt protocols in the event of any agency or public body breaches of cybersecurity. Any questions? Okay, very good. And the last bill is 886 by Leader McCaffrey, an act relating to elections, Rhode Island campaign contributions and expenditures reporting. This act would authorize the reopening of a dissolved campaign account and fund upon notice to the Board of Elections. Any questions? Okay, I think that does it for our 15 bills. At this time, we will now take testimony from the public. For those members of the public who are signed up to testify, if you would kindly state your name, bill number you're testifying on, especially if you are speaking on multiple bills. Do we have the first caller on?
Want a coffee?
Good evening. I believe we have Stephen Brown from the ACLU of Rhode Island speaking on 665 and 797. Welcome to the committee. You may proceed.
Thank you, Madam Chair, members of the committee. I would like to just very briefly express our support for the two bills that you mentioned. 665 is one that would reduce the penalties for certain offenses introduced by Senator Mack. As you know from testimony we regularly submit to this committee, we're always eager to see legislation that looks at criminal penalties and the possibility of reducing them as opposed to increasing them. And so anytime a bill like that is introduced, we hope that the committee will give it serious consideration. In our written testimony, however, we do note we do have a concern with Section 4 of the bill, which we actually think would, as we're reading it, we think it would actually give police greater powers to arrest individuals for these offenses than they currently have now, and we would like to see the deletion of that section. The second bill that we strongly support is S797, the expansion of the Good Samaritan Act bill by Senator Oyer. She gave the statistics, which are so alarming. Certainly any legislation that can have the positive effect of increasing the numbers of lives saved in fighting these drug overdoses should be welcome. Again, like the other bill, we do have a few suggestions in our written testimony for expanding the act to an even greater extent, and we hope the committee would consider those as well. But at the very least, we hope you will give support to the bill as it was introduced. With that, I'll be glad to answer any questions.
Thank you very much for your testimony. Any questions for Steve? We're all set. Thank you very much for joining us this evening.
Thank you.
Next, we'll move on to Senate Bill 740 for testimony. I believe we have Scott Frazier from the Rhode Island Healthcare Association. Welcome to the committee, Mr. Frazier. You're testifying on 740.
Yes, thank you, Madam Chair, members of the committee. Scott Frazier with the Rhode Island Healthcare Association. We represent 63 of the nursing homes in Rhode Island, and on behalf of our members, we are opposed to Senate Bill 740. Our concern is that this makes the language of the statute much too vague. Keeping the word intentional makes the definition very clear, and there's no indication in the bill of who determines that someone is, quote, engaging in this pattern or, quote, failing to provide services. Some examples that concern us. What about resident-to-resident situations? A resident with dementia or a cognitive disability could be acting out. They're not intentionally causing harm, but another resident or family member could claim that it is causing harm to their loved one. The resident might sing or call out loudly, but someone else could claim that that is causing harm to their family member. Another concern under neglect is what about a staffer who may simply forget to do something? A cafeteria worker who accidentally skips a room with a food tray, for example. That's not neglect, it's a simple oversight. It's easily corrected when the error is pointed out. But under this law, the worker in the facility could be in some serious trouble. It just greatly lowers the threshold for abuse, but in our opinion does not add any more protection for the residents. Rhode Island doesn't have a problem with abuse in our homes, thankfully. Our quality is ranked high. In a report released last year, the U.S. Office of Inspector General found that Rhode Island had the lowest number of inspection deficiencies of any state in the nation, and that was over a 4-year period. And in 2019, America's Senior Health Report ranked Rhode Island second in the country in overall quality. If someone has a complaint about a situation, either intentional or not, that's immediately investigated right now by the Department of Health. And if wrongdoing is found, then an immediate plan of correction is ordered, and in some cases there are monetary penalties as well. These protections are already in place. Obviously, if there is intentional harm or abuse or neglect, then by all means these cases should be aggressively investigated, but we feel that removing this one word will lead to numerous unnecessary investigations. And for these reasons, we're opposed to the legislation. Thank you.
Thank you very much. Any questions of Mr. Frazier? Okay, seeing none at this time, thank you for joining us this evening.
Thank you, Madam Chair.
Good evening. I believe we have Tony DeSisto representing Rhode Island Association for Justice on the line. Welcome to the committee. I believe you're speaking on 740.
I am, Madam Chair. Thank you very much. And, the RIAJ is in support, strongly in support of this, I think, very good and common sense legislation. And I have to say that, Senator Lombardi made a very good point. Willful and neglect are two different terms, and neglect necessarily is not willful. I should add, by the way, Madam Chair, on this bill, that the federal government does not have that term in its similar statutes. And at least 13 other states do not have willful in a definition of neglect. It seems to me that our seniors should have a level of care that does not include negligence in dealing with them. And I should also say that the standard of care for developmentally disabled persons in Rhode Island does not have the term willful for abuse and neglect in their standard of care, too. So for those reasons, we strongly support this good common sense legislation, which is protective of our seniors. If you have any questions, I'd be happy to answer them.
Oh, here's another pen.
Thank you very much. Any questions for Mr. DeSisto? Okay. We're all set. We don't have any questions at this time. Thank you for joining us.
That one's blue ink, too.
Good evening. Welcome to the Committee on Judiciary. I believe we have Bella Robinson from Call Off Your Old Tired Ethics, speaking on 771. Do we have Bella on the line?
Yes, you do. Thank you so much. I want to thank Senator Mack and the committee for listening to my testimony. So my name is Bella Robinson. I'm the executive director of Coyote, Rhode Island. We are the only sex worker rights organization in the state, and we have conducted numerous surveys in partnership with Brown University to understand the effects of recriminalizing prostitution in 2009. What we have seen is very little trafficking cases. In 2019, nationwide, the FBI only reported 19 cases. And our prostitution arrests are lower than they've been in 30 years. But we do support this bill, even though we don't think it goes far enough. We think a civil fine is better than being arrested, having your name and picture spread all over the news to ruin your reputation, which would guarantee that you can't leave the sex industry because of the stigma attached to it. We also, the ACLU produced some data back in 2009 for another hearing and showed that over 89% of the prostitution arrests over the past several years have been women. And yet they claimed they wanted to protect the women when they criminalized us. So I also want to point out that we also have a bill from Mark Williams, which is H5250, that is asking to create a study commission to study this that would bring sex workers, Department of Health, academics.
Ms. Robinson? Ms.
Yes.
Robinson, if you could stick to 771, please.
Okay. But basically, we obviously need more, our legislatures need to understand more of the issues, and they're not going to if they don't engage with the people affected. So again, I sent in written testimony that provides a lot of informational links, and I hope that legislatures will read it, and please feel free to reach out to us if people have other questions. And again, I support the bill, and I urge you to vote yes for it. Thank you.
Thank you for your written testimony and for your testimony this evening. Any questions of committee members? Okay, seeing none at this time, thank you, Ms. Robinson.
Thank you.
Good evening. Welcome to the Committee on Judiciary. I believe we have Melissa Brodu representing decriminalized sex work. Did I say your last name correctly?
Yes, that's correct. Melissa Bruto. Thank you so much.
You may begin.
Thank you. I am testifying in support of Senator Mack's bill 771. Thank you so much for giving me this opportunity. I'm a longtime attorney and advocate for sex workers and survivors of human trafficking. I want to thank the committee for considering this incredibly important issue. I fully support decriminalization because criminalization creates endless amounts of barriers for individuals in the sex industry, right? It creates barriers to immigration, employment, the inability of people to report crimes committed against them, barriers to housing, and barriers to family stability. So I applaud the committee and Senator Mack and her their co-sponsors, for this incredible piece of legislation. Studies have consistently shown that criminalization harms sex workers and survivors of human trafficking, and I know from representing survivors of human trafficking myself that the myriad barriers that exist for people that are trying to escape their trafficker and perhaps leave the industry altogether, and they're continually held back, right, by their criminal record and all of the barriers that I outlined earlier. The one thing I would suggest, as wonderful as I think this move is in the right direction, that there be no civil penalties either, right? So many people are economically marginalized, and continuing to have any kind of fine for people that are in the sex industry would continue to place a barrier. And I also have questions just about how that would be enforced as well. And I know that there was a comment earlier from a senator related to, well, people having multiple arrests. And in my significant experience advocating for survivors, that is a very big indicator of human trafficking. So when I see a client come to me who has many arrests, above 5, that usually is a pretty clear indicator that they've been trafficked. So thank you so much. I really appreciate the time and that this committee is considering this important issue. Thank you so much.
And you're welcome. Thank you for joining us this evening. I don't see any questions for you right now. Again, have a nice evening. Thank you. Welcome to our committee. I believe we have Hannah Stern from the ACLU of Rhode Island. You may begin your testimony.
Thank you, Madam Chair. I'm testifying on 2 pieces of legislation tonight. Would you like me to do both of those right now?
Yes, I believe you're signed up for 771 and 667.
Yes, I am. Do you have a preference on where I begin, or should I just go with
let me know what bill you're talking on.
Great. All right, so I'll start with 771, and then I'll do 667 after. So thank you, Madam Chair, members of the committee, for your time this evening. My name is Hannah Stern, testifying on behalf of the ACLU of Rhode Island in very strong support of S771. And we'd like to thank Senator Mack for introducing this bill. In 2009, when the legislature enacted the legislation which essentially reversed the provision in our laws, which had inadvertently decriminalized indoor commercial sexual activity, our organization testified in opposition to that bill, and we're very glad to support this bill today, which would seek to appropriately and permanently decriminalize sex work. We have long opposed laws which criminalize consensual sexual activity, and the current criminalization of sex work really only reduces the safety and autonomy of sex workers and creates a criminal offense out of a victimless interaction. Often what we see is that the raids done on the street of both sex workers and Johns really only serve to humiliate and penalize consenting adults, and are further just really counterproductive in that they give sex workers a criminal record under the guise of helping them. So what decriminalization most importantly would do is ensure that sex workers can care for their health and safety and autonomy without inappropriate stigmatization, and it would ensure that our justice system is really just not being utilized to take unnecessarily punitive action against individuals engaging in consensual behavior, or to fulfill a specific moral narrative, which is ultimately very harmful to those who are engaging in sex work. So thank you for your time. We're glad to urge passage of this important bill. I'd be happy to take any questions on 771 before I continue to 667.
I don't see any questions at this time. You may begin 667.
Thank you again. Thank you, Madam Chair and members of the committee, for your time. Hannah Stern on behalf of the ACLU of Rhode Island in opposition to this legislation, S667. We're very sensitive to the situations that this bill seeks to address, but we just think that the sheer breadth of the language included in this bill could inadvertently criminalize very innocent and consensual young adult relationships. Just to give a few examples, especially because of the definition of phrases like position of authority in this legislation, we can imagine circumstances where, for example, an 18-year-old and a 16-year-old in a relationship who volunteer together, but the 18-year-old technically has seniority, this relationship, otherwise consensual, could be criminalized under this bill. And this bill would also apply to anyone acting in a, quote, parental responsibility, which we think could be applied to an extraordinary number of very benign activities. You know, a 20-year-old who drives their 17-year-old partner home from school may fall under this. And while people can disagree about the appropriateness of such relationships, they just really should not carry the potential weight of a potential felony conviction. So we do urge rejection of this legislation for these reasons. Thank you very much for your time. I'd be happy to take any questions.
Thank you, Ms. Stern. I don't see any questions at this time. Thank you for joining us this evening.
Have a good night.
You too. We are now on to Bill number 797. I believe we have Ryan Holt from the Attorney General's office. Welcome to the committee.
Thank you, Madam Chair, and good evening. This is Ryan Holt, the Director of Legislative Affairs for Attorney General Noronha, testifying in support of Senate Bill 797, sponsored by Senator Oyer. We agree with what Senator Oyer said earlier in the hearing, that these changes will encourage folks to call 911 during a medical emergency, and that's good. And we do agree that was the intent behind this legislation. So that is a good thing. We would like to, however, just suggest a change to Section 2. In talking to some of the advocates who I know have supported this legislation, the Section 2 is, I believe, intended to strengthen the Good Samaritan overdose report, which our office produces every year. And I think it's probably more appropriate to amend Section 5 of this statute, which would be 21-28.9-5, and include a best efforts clause for law enforcement to submit reports to us in a timely fashion, and I think also probably extending the deadline. Right now, it's a early January deadline. I think sometime in February would probably give law enforcement more time to comply and get us more complete data to create an annual report here. But otherwise, we do support this legislation. We think the intent behind it is good, and if there are any questions, I'm happy to take them now.
Thank you, Ryan, and you work with the senator with those regarding those changes.
Happy to.
Any other questions of Ryan? Next, thank you for joining us this evening.
Thank you, Madam Chair.
Welcome to the committee. I believe we have Haley McKeefe representing Super PAC. You may begin your testimony on 797.
Thank you. Good evening, Chairwoman Coyne, and honorable members of the committee. My name is Haley McKee. I am a co-chair of the Super PAC, a former IV drug user, and a person who works in substance use disorder treatment. And I'm here in support of Bill S797. So I do regular Narcan trainings with people who use drugs, and there's a step process. So we tell people the first step is always to call 911, and then obviously administer them naloxone, Narcan, whatever you call it, give them oxygen. And we've had to add, unfortunately, an extra step to this process, which is the rescue position, right, which was originally designed to answer a door for an EMS person or some sort of assistance, but we've had to add on, if you don't feel safe interacting with law enforcement, put people in the rescue position, and if you don't feel safe, you can leave. But we're encouraging people to do the right thing. So anecdotal stories from people who use drugs that we hear are that they don't feel safe calling 911 in the event of an overdose because of the fact that they know that people are prosecuted so frequently. So we're a fan of this bill because of the fact that this act needs to be expanded, and according to the 2020 report on impact of Good Samaritan overdose prevention and on law enforcement, they've listed incidents in which the law enforcement agency was barred from charging criminal offenses due to immunity provisions, as well as other criminal offenses that were charged and or prosecuted resulting from an agency's response to requests for medical assistance. And sadly, last year, Central Falls, Burrillville, Coventry, Lincoln, Woonsocket, etc., were 0 for 0, which means that they're not reporting any kind of incident. And additionally, Rhode Island State Police was 0 for 10, and reason that every single case was DUI related. So there were no exemptions made for Good Samaritan protections. So we're in support of the timely filing for any report or study that they were required to file by state statute. This was kind of based roughly on all medical emergencies that's in the current version of this bill, following a DeSalvio case. And we feel that that should be extended to any medical emergency. So when somebody has a heart attack or a stroke, they're not typically asking for people for identification on scene to have called for support, or frisking them, or checking their pockets, or looking for paraphernalia. And it would be nice if these kinds of scenarios were treated the same. Additionally, we would like to see protections from arrests that extend to arrests related to warrants against any person for failure to appear or comply with a court order, or for failure to make payment of a court-ordered fine, civil assessment, or order of restitution, or bench warrants. We know that people who use drugs are aware of the fact that if they have a warrant out for them for non-payment, that they know that they're not immune to Good Samaritan protections. And we'd also like to make an argument for adding delivery to the current proposed legislation, as people who sell people drugs, who are using drugs, are oftentimes the last point of contact prior to an overdose. So, but we do support this bill in spirit. We would just like to see it extended a little bit more. So if the committee has any questions for me, and I do appreciate your time and your bill, Senator Oyer. Thank you.
Thank you, Ms. McKee. Any questions of this witness? Okay, no questions at this time. Thank you for joining us.
Thank you.
Good evening. Welcome to the committee. I believe we have Peg Langhammer from Day One speaking on Senate Bill 834. You may begin your testimony.
Thank you so much. Thank you, Madam Chair and members of the committee. I am the CEO of Day One, which is the statewide Sexual Assault Resource Center. I've been before this committee many times over the years. I'd like to actually thank Senator Oyer and Leader McCaffrey. Senator Oyer put this bill in last year, and it passed the committee. But you know, with COVID, then everything was put to a halt. So here we are again, and Senator Oyer spoke eloquently about the purpose of this bill and why we need it. Basically, it just eliminates the marital rape exemption, and it we needed to do this for some time. We've had this language in the law for so many years, and it was seen as a compromise when it first passed many years ago. It was seen as protecting married individuals with developmental disabilities, etc. But we know now, we know there is no need for this after many years. We need a clean first-degree sexual assault statute. Most states have done this. Most across the country have closed this loophole, and we need to do the same. And I know so many of you already do support this. And so we strongly support this legislation. We need to eliminate the exemption. A marriage to another human being is not a license to rape. And so we thank you for hearing this, and we look forward to its passage. Thank you so much.
Thank you for your testimony. Any questions of committee members of PEG? Seeing none at this time, thank you again. Good evening. Welcome to our committee. I believe we have Rob Rock from Secretary of State's office. I'm sorry.
Yes, ma'am. No, thank you very much. Good afternoon, Chairwoman and members of the committee. Rob Rock, Director of Elections for Secretary of State Nellie Gorbea. And I would like to testify on 5 bills in whatever manner is best for the committee. Should I just do all 5 and take questions after, or do each one and then stop?
No, you can do all 5 together, but before you begin your testimony, if you would just state the bill number and then state your testimony and so on through the 5 bills, and then we'll see if anybody has any questions.
Great. So I will start with Senate Bill 835, which, Chairwoman, thank you very much for sponsoring on behalf of the Secretary of State's office. Government is in charge of maintaining and protecting information for the public. It serves ensuring this information is protected is critical as cyber threats continue to evolve and place new pressures on the public sector. Therefore, state and municipal governments must remain vigilant, adaptable, and prepared to mitigate risk at every level. Rhode Island has made significant enhancements to the cybersecurity of its election infrastructure. And building on this work, with the understanding that there is no destination, we will ensure that Rhode Islanders are protected against potential cyber threats. So our bill has three main components. First, include the requirement to conduct a cybersecurity assessment of the state's election systems and facilities and the Secretary of State's powers and duties. Two, require the Secretary of State's office to offer annual trainings on cybersecurity best practices to local election officials. And then three, establish a cybersecurity incident response group to establish communication protocols in the event a cybersecurity breach happens at the state or local level. A comprehensive cybersecurity strategy is necessary to ensure Rhode Island is prepared for threats to its state and local government systems. This requires coordination, communication, and strong protocols across Rhode Island government. So again, thank you, Chairwoman, for sponsoring the bill on behalf of the Secretary of State's office. The next bill is Senate Bill 738, and currently our office transmits ballots to military and overseas voters electronically. However, the current law talks about electronic as being fax, and as Senator Archambault mentioned, fax ballots rarely make it to voters because fax machines are rare and outdated. This bill would allow our office to establish updated methods of electronically transmitting ballots. The bill would ensure system security by requiring an independent security review and a demonstration of compliance with National Institute of Standards and Technology Cybersecurity Framework Guidelines. And these guidelines are the gold standard in cybersecurity. And I would like to offer the following language change that we can work with the sponsors on in line 18, page 2, that in case NIST goes away, we'd like to make sure that there's a federal cybersecurity framework guideline successor designated agency in case NIST goes away. So just to ensure that that framework and guidelines remains regardless. And then additionally, we recommend defining a disabled voter consistent with Rhode Island General Law 1722-1, which defines a disabled person as someone who is incapacitated to such an extent that it would be an undue hardship to vote at the polls because of illness, mental or physical disability, blindness, or serious impairment of mobility. Currently, over 15 states allow for the electronic transmission of ballots, and I believe we should do whatever possible that we can to ensure the men and women serving our country and the disabled community are provided with modern ways to securely receiving and returning their ballots. The next bill is Senate Bill 662, which our office opposes. There will be several voters, if this legislation passes, who will be disenfranchised, particularly voters who live by themselves and older voters who rely on others for assistance. Boyfriends, girlfriends, close or best friends, neighbors, and a host of other trusted people would not be able to assist a voter by returning their mail ballot if this legislation passes. In 2020, many voters felt more comfortable using the drop boxes than putting their ballot in the mail, and voters should have the right to designate whoever they trust to return their ballot. This legislation would also be very difficult to enforce, with 24-hour-a-day, 7-day drop boxes being so popular in 2020. It would be difficult for election officials to determine who left a mail ballot in the drop box. The bottom line is we believe this legislation will make it more difficult for people to vote. Senate Bill 666, our office also opposes this legislation. In fact, our office supported several bills that would remove the witness notary requirement from the mail ballot process altogether. Only 11 states currently have a witness or notary requirement, and only us in Alabama have the 2 witnesses or notary requirement. Over 350,000 voters voted by mail in 2020 and 2021 without one allegation of voter impersonating another voter. The witness notary requirement is unnecessary burden placed on voters. Secretary Gorbea believes that removing the need for someone to witness or notarize a mail ballot is the more secure way to vote because it eliminates the issue of ballot harvesting by making sure the voter does not need anyone else to help cast their ballot. Using signature verification as the mechanism to verify identity is done in most states and is the most secure method to prevent fraud. And then the final bill I'd like to testify on is Senate Bill 799. We have not taken a position on this bill, but we have had productive conversations with the supporters of the bill and the DMV. Our main concern is voters not being notified at the point of transaction about them being registered to vote. It is not until after their name has been added to the voter list that they are contacted and given the option to remove themselves from the voter list. We appreciate discussions with the sponsors and look forward to continued conversations to see if we can come to an agreement on the best approach to automatic voter registration. So thank you, Chairwoman and members of the committee, and I'm happy to answer any questions on the bill that I testified on.
Very thorough testimony. Thank you. Any questions of, yes, Senator Archambault has a question for you.
Thank you, Madam Chair. Rob, impressive, succinct, to the point, excellent testimony. I took notes on your comments on 793, page 2, line 18, and about requiring that the NIST stay as a framework for the guidelines. And then that's a great point about defining disability, 1720, 2.1. Is that the statute? Just want to make sure I have that right. 1720.
It's 1720-2 and then section 1 within that statute.
Okay, section 1 within it. Okay, thank you. Where it's defined. And I appreciate your testimony, your support, and you're making me think about it, an analogy here. I'll be quick. But you know, we have our social security number, our birth date, our place of employment, salary information, all sorts of information that a hacker could get that we use all the time. Things as simple as Amazon. I bought some stuff for the farm from Amazon the other day, and I went online, whole bunch of my secured information. Always makes me have a little squeamish feeling, but I do it because that's the age we live in, right? And knock on some wood in front of me here, we don't generally have issues. I don't. So with that level of information that we're putting out daily across this country, and the fact that we still use fax machines, it's astounding that, quite frankly, anybody would oppose legislation that has these 3 tiers of protections built into them, and these checks and balances, and would enable so many disabled and our soldiers in times of war in the far-flung corners of this world to be able to cast their ballots and not be disenfranchised. I appreciate you, Rob. Thank you.
Thank you. And I believe Senator Reptakis has a question for you, too. Go ahead, Senator.
Rob, thank you, Madam Chair. Rob, quick question. Last year's election, how many mail ballots did we have versus early voting? Precisely, excuse me. We allowed 2 weeks early voting, and I think that was probably a lot safer to allow those individuals to vote earlier pertaining to mail ballots. Because again, on the mail ballot issue, prior to last year, if we go back to 2016, 2014, 2016, I think 2018, we used the concept of emergency ballots because it was a last-minute issue, meaning the election and the opportunity to vote were only on election day. But we didn't have the opportunity to expand the 2 weeks. I think expanding the right for someone to vote, maybe even going to 3 weeks, will probably make it a lot easier. I know we're going into detail on mail ballots, but what was the numbers versus either the general election or the primary? If you have those numbers or ballpark, do we have more early voting individuals voting than mail ballots?
We did not, but it was close. So essentially, it was pretty split evenly among the 3 ways you can vote, whether it's in person at the polls, in person early, or by mail. More specifically, there were about 190,000 mail ballots for November, and about 150,000 people voted early. And currently, we have that 20-day window where you can go and vote early, and it's still labeled as an emergency ballot technically by law, but we believe, and it sounds like, Senator, I'm agreeing with you, that we believe that it should be called what it is, and that's called early voting. Right now, it's called emergency voting, but we believe it should be called early voting in the 20 days during the 20 days before the election, because that's exactly what it is. It's voting before Election Day. But it was 149,000 people roughly voted during the 20 days leading up to Election Day in November, and 190,000 or so roughly voted by mail.
And I apologize that again, it's 3 weeks. You're right, 20 days. Do you think increasing it to 28 days in the future would also help?
I think the 20 days is a good day because currently the mail ballot deadline for an election is 21 days before the election. So the next day is a great day to start the early voting period in the 20-day, and that's why it's the 20 days. And our office believes that 20 days is a good mark because of the mail ballot deadline. So it kind of coincides with the mail ballot deadline.
Right, because well, not my concern, but my opinion is that I like to see us in the future election is move to early voting and then the day of the voting, and stay away from the mail ballots, because the mail ballots has different opinions. Again, there's a signature requirement, the drop box. So I like the emphasis to go toward that early voting, because it's so simple. You go and vote and you're done. Again, getting the mail ballot, getting if there's going to be signatures in the future, it gets a little more, I think, more tedious and more, I don't want to use more difficult, but I like the early voting process. Thank you.
And Senator, we're happy to work with you on expanding the early voting to 28 days. It's something that certainly we're happy to look at. I mean, ultimately, Secretary Gorbea wants to make sure that we make it as easy as possible for people to cast a ballot. So we're certainly open to extending the early voting time frame if it's what you wish. We're happy to work with you on that.
Thank you.
Thank you very much. Any other questions of Rob? Okay, seeing none at this time, thank you so much for your testimony this evening. Good evening. Welcome to the committee. I believe we have Randall Rose on the line speaking on 663. You may begin your testimony.
Thank you, Madam Chair. So I am speaking against 663, the constitutional amendment to say that there can be no state regulations unless the General Assembly approves of those regulations. This bill is a very bad idea. Basically it allows a lot of more bad faith and deceptive conduct in government. If this bill passes, some people in the General Assembly will pass laws and proudly announce how great their law is, and then not allow the regulations that would implement the law to come into effect. So the law will end up being a dead letter. And the bill makes it very easy to do that. It doesn't just say that the General Assembly can veto regulations. It actually says that regulations can never come into effect until the General Assembly affirmatively passes a measure approving the regulations. So if the General Assembly does nothing, no regulation can come into effect. Makes it very easy for lobbyists who are opposing the vast majority of the public, the lobbyists who are against the vast majority of the public, to lobby the General Assembly to not approve a regulation, so that even if the majority of Rhode Islanders want a regulation, lobbyists can just make a deal with a few members of the General Assembly and say, no, we don't want any regulations coming into effect, which again makes a bill a dead letter if there's no implementing regulations. I do understand that it's useful to have some oversight of regulations, but already even without this bill, the General Assembly always has the option to reverse any regulation. If a regulation is bad enough, it can always be reversed by a simple act of the General Assembly. And if you want tighter oversight of regulations, I think the right way to do that is to give the people of Rhode Island the right to do a voter initiative for the specific purpose of repealing any regulation that's gone wrong. And it should be the people of Rhode Island who have that power. Right now, already, the General Assembly is far more powerful than the executive branch, and this bill would just strengthen the General Assembly. It wouldn't be it would strengthen the General Assembly in relation to the executive branch, and it would allow the General Assembly to kill regulations with no sunshine whatsoever, no public disclosure. Just by not taking any act, the regulations would be killed. And that's not the way the public should operate. Right now, the executive branch, when they issue the executive branch issues regulations, there's a lot of sunshine, there's a lot of public disclosure and public hearings and a clear process for public comments. But this bill allows regulations to be undone with no public hearings, no public comments, just by the General Assembly quietly taking no action as part of a quiet backroom deal that the public never hears about. That's not the way it should be. This is a very bad bill, and I oppose it. Thank you.
Thank you very much. Any questions of Randall Rose? No questions for you right now. Thank you for joining us this evening. Good evening. Welcome to our committee. I believe we have C.J. Coles from Verified Voting to speak on 738. You may begin your testimony.
Yes. Thank you, Madam Chair and members of the committee for your time today. My name is C.J. Coles, and I represent Verified Voting, a national, nonpartisan, nonprofit organization with a mission to strengthen democracy for all voters by promoting the responsible use of technology in elections. And I am here today to testify in opposition to SB 738. Multiple cybersecurity experts have concluded that internet voting is insecure. The National Academies of Sciences, Engineering, and Medicine released a report in 2018 outlining just how dangerous internet voting is. In the lead-up to the 2020 general election, the Department of Homeland Security, the FBI, and the National Institute for Science and Technology, NIST, said, quote, securing the return of voted ballots via the internet while ensuring ballot integrity and maintaining voter privacy is difficult, if not impossible, at this time. That same group of agencies went on to say, quote, they recommend paper ballot return as electronic ballot return technologies are high risk, even with controls in place, end quote. Blockchain does not solve the security issues inherent to internet voting. That National Academies report stated that blockchain technology does little to solve the fundamental security issues of elections, and indeed, blockchains introduce additional security vulnerabilities. Blockchain technology is designed to keep information secure once it is received. It cannot defend against the multitude of threats to that information before it is entered in the blockchain, and voters cannot verify their votes are entered into the blockchain correctly without compromising ballot security. Recording ballots on a blockchain also risks ballot secrecy if the encryption keys are not properly protected or software errors allow decryption of individual ballots. It is not lost on us the profound challenges you face to assure every voter's ability to vote. I'm a former election official myself. But verified voting strongly supports interventions to assure voters equal opportunity and access to cast their ballots securely and verifiably. Electronic return does not allow for this to happen. Rhode Island was one of the first states to implement risk-limiting audits to increase public confidence in election results. If this measure is adopted, that job becomes much harder because your elections will become much less verifiable. I will note that we do not object to delivering a blank ballot electronically to a voter. It is the electronic voted ballot return that poses the significant security risk. At a time when election security and public confidence are under attack, electronic return of voted ballots presents a slippery slope to vulnerable and untrustworthy elections. We therefore urge that SB 738 be rejected or amended to allow electronic delivery only and not electronic return. Thank you, Madam Chair, members of the committee, and I'm happy to answer any questions.
Thank you. Senator Archibald has a question for you.
Yeah, thank you. First and foremost, I appreciate your testimony, but I have to say I take great exception and disagree entirely with the mindset that the electronic means of returning a ballot cannot be secured, particularly for all the reasons I stated earlier, which I'm sure you were probably listening to as you were waiting for your testimony, and that means the FBI, Homeland Security, and others, not from this 2018 study that was put forth, but from data that's gathered and how they transmit their own secured and classified information. That said, on a very practical level, how do you take somebody, and this is somewhat rhetorical, but if you can answer it, how do you take a soldier that's sitting in Afghanistan where they don't have a fax machine and say that they're going to have the means to be able to return a ballot to a secure spot, and say that juxtaposed with sending it through a transmission, as we're going to have here let me finish please, electronically, as we're doing here, and have that sent back with 3 checks and balances on it. How do you compare the two and say that somehow it's better for the soldier who has may not have a fax machine and be able to return the transmission, that somehow that's the better course because of these risks compared to sending it through this, what I'm arguing is a secured means?
Mr. Coles, would you like to respond?
Yes, thank you, Madam Chair and Senator Archambault. I appreciate the question and your statement about Homeland Security, FBI, and NIST. I will say that what I was basing my testimony on was actual quotes taken from an unclassified memo sent by Homeland Security, FBI, and NIST to state and local governments saying that they recommend paper and they view electronic ballot return as high risk. So those weren't my words. Those weren't Verified Voting's words. Those were quotes taken from their unclassified memo. On your question about the soldier or voters with disabilities, I will say again, our argument in opposition to this measure is security only. It is not on access. As a former election official myself, again, I know providing equal access and convenient access also has to be balanced with security. And so I do think that if your statutes do say that delivering a ballot electronically only means using a fax machine, that is, delivering a blank ballot to a voter via fax, I would agree that that probably needs to be updated. I think delivering an electronic ballot via email, again, a blank ballot via email, poses a very low risk. And again, FBI and NIST and Homeland Security do say that delivering a blank ballot electronically poses a low risk through either email, fax, or another web portal. It's the return that poses the significant risk. And so if there is a mechanism or a way that many states across this country utilize to deliver the blank ballot electronically to UOCAVA voters or to voters with disabilities, and then they print that their voted ballot and return it either to the election office if they're able to drive there, or Dropbox locations, or via mail. And again, UOCAVA voters, they get their ballots 45 days before the election, and they can return their voted ballot via mail, then that would be a much more secure means than putting it through an electronic portal.
Thank you, Mr. Coles. Senator Archibald?
Yeah, just, Madam Chair, just one point of qualification. I appreciate your response back, but you know that this bill has nothing to do with blockchain voting, right? I just want to be clear about that. And I'm not sure, are you in Rhode Island, or if I may, are you in another state?
I physically am located in a different state, though I did travel to Rhode Island in November and helped the Department of Elections conduct that risk limiting audit.
Thank you, Mr. Coles. I don't see any other questions. Thank you. Our next witness. Good evening. Welcome to the committee. I believe we have John Marion on from Common Cause, Rhode Island, speaking on 738 and 799. You may begin.
Good evening, Chair Coyne. Thank you very much, and members of the committee. Yes, I'm John Marion on behalf of Common Cause, Rhode Island. I appreciate your taking my testimony. I'm going to testify, as you said, on 738 in opposition and 799 in support. I'll start with 738. Common Cause opposes S738 because it allows for the electronic return of voted ballots. Common Cause is committed to an equitable voting system that provides voters with disabilities with equal access to the ballot. However, we believe the electronic return, and I emphasize the return of the ballot, creates a situation where a voter with disabilities is not being afforded the same safety and security as other voters who chose to vote by mail or in person. As we outlined in our written testimony, 4 federal agencies, including the FBI, have said unequivocally that electronic return of ballots presents a significant risk. Common Cause supports the electronic delivery of the ballot to the voter, who then can use assistive technology to vote the ballot if needed and return it by mail. We would encourage an amendment to this bill that would remove the electronic return option and substitute a requirement that the Secretary of State send any voter choosing to receive their ballot in this manner a postage paid return envelope. The legislation suggests that the National Institute of Standards and Technologies approves of the use of this technology. They absolutely do not. They are one of the 4 federal agencies that signed the statement that we cite in our written testimony. NIST does not certify voting systems, period. That is the responsibility of the Election Assistance Commission. So any implication or that NIST does certify this sort of system is incorrect. Rhode Island is a national leader in election security because of our hand-marked paper ballots, along with our risk-limiting audits. If this legislation passes as written, we will take a significant step backward in election security. Common Cause believes deeply in equal access to the ballot for every voter, but we cannot risk the security of our entire system.
I believe, excuse me, Mr. Marion, I believe
Yeah.
Senator Archambault does have a follow-up question for you on 738.
Yeah, thanks. I just want to be clear here, John, good evening, and respectfully, I never
evening.
said that NIST supported it. What I said was, if you go to page 2, and you see the 3 tenets in the bill that are the security review requirements. First, it has to have more than one independent security review. That's line 16. 17 through 18 demonstrates the system meets the National Institute of Standards and Technology, NIST, Cyber Security Framework Guidelines. So it has to meet their standard. It doesn't say that they have to be the ones that endorse it. It says it has to meet their standard. So I think you may have misstated what I said, and it may not have been intentional, but I don't want that misconstrued. And you can continue with your testimony, but I want to be clear. When you cite the FBI and you talk about how they don't support this, I want to go back to what I said earlier. The FBI uses secured portals for all of their information, just like all other national agencies. So it can be misconstrued to the populace out there that somehow having ballots returned through the same secure portal systems is not commensurate with or in keeping with what already happens within our federal agencies. I think that's a bit disingenuous, overreactive, particularly when we're talking about the current technology being a fax machine. And you could be in the far-flung corners of the world in Afghanistan, for example, have no fax machine, no post office, no way to return it. You can sit here and say, well, we support equal access. However, we don't support and that soldier is disenfranchised. You can go ahead.
Thank you, Senator. John, if you want to continue, either with 738 or move on to 799.
I'm sure. Thank you. And thank you, Senator Archambault, for your comments. I didn't mean to imply, I wasn't referring to your testimony on the bill. I just want to respectfully disagree about your point. NIST has some general principles around cybersecurity that might apply to hospitals or pipelines or all sorts of things. But in a separate statement, NIST has said, along with the FBI, the Election Assistance Commission, and the Department of Homeland Security, that there is no safe system for the electronic return of ballots, and that any system of the electronic return of ballots presents, in their words, a significant risk. I would just like to point out, and I'm going to get the committee a letter, the cryptographer who invented all online transactions use what's referred to as RSA encryption. It's a type of encryption. The RSA stands for the last name of the 3 inventors of that encryption. R stands for Rivest, Ron Rivest. He is a computer scientist at MIT. He helped the state of Rhode Island develop its risk-limiting audits. He won the Turing Prize, which is the Nobel of computer science. He is considered the most important cryptographer alive today. Ron Rivest opposes the electronic return of ballots. The election security community stands united on this issue. We all acknowledge that there are equity issues, and we're working on the equity issues. So I'll leave it at that and move on to 7999 briefly.
Please. Yes, thank you.
Senator Cano's legislation. We strongly support this legislation. In 2017, Rhode Island enacted automatic voter registration. There are 2 ways to do automatic voter registration. One is at the point of contact at the government agency, currently at the DMV, by including the opportunity for the voter to opt out from registering or updating their registration during the transaction. This is what we started doing in 2018. It has worked well to increase registration of eligible voters and capture additional updates to addresses. S799 proposes a different approach to automatic voter registration. It takes the opt-out opportunity and puts it after the transaction by sending a mailing to the voter who has conducted business with the DMV or other government agency that provides them with the opportunity to opt out. There are several benefits to this type of automatic voter registration. First, it makes it more efficient for the government agency by removing registration as a responsibility. Second, it makes it more accurate for the voter rolls by reducing the opportunity for data entry errors, which can be significant. And finally, it increases the number of eligible voters who register, and it keeps the voter rolls cleaner by capturing more address updates. This is part of an effort that Common Cause, the Secretary of State, and others have engaged in for years to modernize our elections in Rhode Island, and we hope you give it consideration. I'm happy to answer questions about 799 as well.
Thank you. I don't see any additional questions for you. Senator Archambault.
Just one, and I'll be very brief. John, I always appreciate you, but I'm going to end with this. You said something that jumped out at me. You said you're working on the equities, and to me, working on the equities by maintaining the status quo of fax machines is disenfranchisement over the use of what I would argue are secured portals and what's used in our federal governments for technology every day. Finally, this NIST report that you cite does say that fax machines are the worst option. So when I weigh things out, I think about somebody who's not going to be able to vote, and as I said, the far-flung corners of the world, and I think of somebody who's disabled, who's not going to be able to have a fax machine and return it, versus somebody who could use a secured portal that's going to go through 3 tiers of checks and balances, and it's an obvious no-brainer to me. Anyways, I appreciate your testimony. Thank you, Madam Chair.
Thank you.
Thank you.
I don't see any other questions. Thank you very much, John. Good evening. Welcome to the committee. I believe we have Robert Marshall from Rhode Island Developmental Disabilities Council speaking on 738. Welcome to our committee. You may begin your testimony.
Thank you, Chairwoman, for allowing me to appear on behalf of the Developmental Disabilities Council. If you don't mind, I would also like to testify on 662, if that's okay.
Yes. Go ahead.
All right. So I'll start with 738. Which is the electronic voting for military and people with disabilities. We think we should take a serious look at this. We have listened to the concerns about the returns, and we are asking that you take a look at least sending the ballots out in a way that they can be used with adaptive equipment, which makes a lot more people able to vote independently. With the way they're currently sent, where it arrives on paper, if you cannot work on paper because of your disability, then it forces you in the situation where you have to have someone assist you, which, as we all know, eliminates the privacy and is not what was intended for voting. So since the technology is available to send it securely, with no risk, to be able to be used with adaptive equipment, so that the person can read it and fill it out without assistance using their adaptive equipment, and then send it back. And then, if we could send it back electronically, obviously that would be easier. But at least get it there that way, so in a format that can be used that way. And then, if we need to, until something secure can be developed for return, we'll just send it out and then have the person mail it back. I will take questions on that, or do you want me to go on to 662?
Yeah, we don't have any questions right now. You may proceed with 662, please.
Okay, 662 is a problem that we want you to look at. This tightening up to fix a problem that no one really believes is there would have a real adverse effect on individuals with disabilities that are using drop boxes of mail to vote. I give you as an example, say that you had 4 people living in one of the Buddha group homes, all of them eligible to vote, all of them perfectly capable of voting, and perfectly capable of voting independently, but all 4 of them in wheelchairs. The right now, what likely would happen is those people would go to their rooms, fill out their ballot, do the whole thing, get it into the envelope, and then more often than not, one of the staff people would transport that to a drop box or the post office. With the way that this bill would change things, what would have to happen instead of that is all four of those people would have to be loaded into a van, driven to a drop box, taken out of the van, and personally put the thing into the drop box. And what are we accomplishing? We're getting rid of fraud that doesn't exist. Another big lie. And it's just making it more difficult. It's likely that some of those votes will be lost in the process because either the van wasn't available that day, the four people weren't all available at the same time, there wasn't enough staff to split the group into two. All those things then become issues that weren't issues the way that it's currently done. So we would like you to take a serious look at that issue in addressing this bill.
Thank you.
And lastly, if I could just respond quickly to something that I think Senator Lombardi said about wanting to expand early voting and do that in a way that would move towards either eliminating or reducing the use of mail ballots. For the disability community, that again sounds good, but it would be a real hardship. The people that I just described, that would not help them. That would, then back to the same thing. All four of them have to be transported for early voting, as opposed to being able to do it where they live. And there are many people in that situation that getting to a specific place to do the voting is a real impediment. So I have nothing against expanding early voting and calling it early voting like it should be, but I think if we're doing that as a way to reduce the amount of mail ballots or make it more difficult to use mail ballots, that would be a real problem.
Thank you very much. Thank you for your testimony.
Thank you.
I don't believe we have any questions at this time. Next witness.
Next witness is Daniel Muse. I'm not sure if I'm pronouncing that correctly. Could you help me out with that?
That is correct. This is Daniel Muse on behalf of the Center for Secure and Modern Elections, testifying on Bill 799 by Chair Cano.
Thank you. You may proceed.
Great. Thanks so much. So thank you, committee members. I'm testifying on Bill 799, which John Marion just spoke to in the witness before. So this legislation is an update to automatic voter registration, which Rhode Island has had in place since 2018. And the update here, as John described ably, moves the operation of the opt-out from kind of at the point of service to post-service, right? So what that does, kind of from a policy and operations perspective, is it saves time at the transaction at the DMV, right? So if you've updated your license or maybe gone to get a real ID in the last couple of years, you've noticed there's an addition on the DMV forms that you're filling out to allow you to opt out of voter registration. This legislation would move that opt out kind of to after the transaction, so that if you are deemed to be an eligible voter, and we know that you'd be an eligible voter because we have your residence and your date of birth from the DMV form, but we also know as you're going through the real ID process at the DMV that you were able to prove yourself as a citizen, which makes you an eligible voter. Those are the folks that get kind of moved into the automatic voter registration process, where the data is automatically transferred to the Secretary of State's office. There can be a check to see, is this information new, right? Is this all the same? Do we already have you in the system? Or is something updated? Maybe you have a new address. Maybe you're not in the system. And that would generate an outreach to the person to say, hey, we have your information. We can register you to vote. Don't do anything, and we'll get that information into the system. Or, add information, whether or not you want to be affiliated with a party, or no, actually, I wish not to be registered to vote at this time. And so it allows that information to happen after the transaction. It's important for saving time at the DMV for transaction times, but it's also important as we look at other agencies in the state that can update and move into the automatic voter registration space. And the Medicaid program is a great example of that. So folks that are applying for Medicaid or renewing their application for Medicaid also have a citizenship check. This check is done through an electronic verification with federal services, through the Social Security Administration. It is the source of truth for citizenship validation for the Medicaid program. And by moving the information to kind of this opt-out post-transaction, it allows that citizenship verification to take place at Medicaid through the process and make sure that the only folks that get sent over to the system are valid voters. So that's kind of the main thrust behind the legislation. We're really excited about this. We've been working on this in a number of different states, and it is being the legislation is passed in Colorado, New York, and Maryland, and it has been kind of on the docket in a number of other states, including California and Oregon right now. So we're very excited about this legislation, and I'm happy to answer any questions that the committee might have.
Thank you, Mr. Muse. Are there any questions for this witness from any members of the committee? No, hearing none. Thank you very much. You have a nice evening.
Thank you so much.
We're going to move on to our last bill, Senate Bill 886 by Senator McCaffrey, and we have Robert Cushman. Mr. Cushman?
Yes, thank you.
Yes, welcome to the committee. You may proceed. You're welcome. Go ahead.
Yeah, I'm just calling in support of Bill 886. I want to thank Senator McCaffrey for sponsoring this. And just to give you a little bit of background, I'm a former elected official in Warwick, and I don't think I need to say this to you folks on your committee here, but running for office takes a lot of time. The sacrifices of running a campaign, the paperwork, the forms, the things you have to do to fill out, campaign finance reports, and then when you get in office, the amount of time that you're taking away from your families and things like that is significant. So that's why I support this legislation. So let me just give you a little bit of background on the specific situation that I was in, and I called Senator McCaffrey on this. I was in elected office from 2003 to 2008, and in 2008 I lost my reelection. From this period on, from 2009 now to 2021, I've kept my campaign finance account open because I'm thinking in the future maybe I might want to run again. And I think the reason that this legislation will be very important, it'll, I think, help promote other situations where let's say a young person comes in, they run for office, let's say in their 20s or something like that, and they don't win. They have some campaign finance amounts that balances that are due because they decide to fund their own account. And, because of whatever reasons they decide that they're not going to run right now, but maybe in the future they want to run. And that's kind of the situation that I'm in right now. I mean, maybe someday I do want to maybe get back in and run again. So what I've had to do is to keep my account open, is to file the quarterly reports that everybody on the committee probably knows about because they have to do that themselves. And I have no transactions that are been done in the last 13 years, no money coming in, no money going out, and I actually have a negative, $25,000 balance in my account. And the reason I've been doing this is because it's the only way by law to keep my account open. So someday, if I want to run, I could use, the same account and, maybe recoup some of these funds. So what I've been required to do is constantly do these quarterly reports and just basically hit the button because there's no transactions. I don't have a bank account or anything like that. And, at one point in time, I actually even forgot to do it. And I almost, I had to write a letter to Mr. Thornton from the campaign Board of Elections and go on the grace that I've never missed a report before. But, the fact that the law requires me to do this just to keep the account open, it doesn't really make any sense. And I think what this legislation will do is allow someone like in a situation that I'm in is to suspend the account So you no longer have to file the reports. But then someday, if I want to run for office again, I could petition, the Board of Elections to reopen the account, and whatever balances that are associated with the account will be reinstated. So that's my story. That was the reason why, I asked Senator McCaffrey to sponsor this, and I'm willing to take any questions from anybody.
Yeah, I just want to say I appreciate your testimony very much. Very articulate, heartfelt, and I didn't even know before tonight this bill was on. Then I was reading the docket and saw what the bill had said and the intent of it. I'm owed campaign debt, actually. I'm still in office, so it doesn't apply. But I'm sitting here thinking to myself, wow, you're talking from a common sense, heartfelt reason. I can't think of a single reason why this bill wouldn't be able to be passed, and it's fair, it's just, there's nothing wrong with it in any way. Anyway, I appreciate your testimony very much. I don't know if there's any questions from any members of the committee. Hearing none, thank you again for your testimony. You have a nice evening.
Thank you, Senator.
That's it. That's our last witness. Do we have a motion to adjourn? Motion to adjourn by Senator Rogers, Senator Aptakis, Senator Royer, and Senator Burke. All those in favor? Aye.
Aye.
None opposed. Thank you, everybody, and thank you, Madam Chair. Have a nice evening.